Hi all. For today's class, we're really looking at does the Supreme Court actually act to defend defendant rights and minority rights, and why we even expect them to do so in the first place. You know, from the first class, you have more sense of the history of the Supreme Court has not always been very favorable to either civil rights, defendants' rights, other than whites accused of murder against blacks, but also that there was a large other areas of pro property owners, striking down minimum wage, breaking unions that led up to the 1930s. And as Rosenberg notes, it was actually a relatively new phenomenon post New Deal, and especially with the Warren Court in the 1960s, that you ended up with essentially a generation of liberal judicial thinkers saying, of course, the court is supposed to protect minority rights. He uses, Chemerinsky as a sort of paradigm of that, but he notes that there's a large question of why we expect that. He notes that back in 1938, there was what was called the Caroline Products decision, which had a much more general purpose, but a small footnote said the courts could act to strike down laws that, quote, restrict those political processes which can ordinarily expected to bring about the repeal of undesirable legislation, i.e., restricting voting rights, and worrying about prejudice against discrete and insular minorities, meaning largely black people at that point, but which has been expanded. Now, it is worth noting, up to that point, most progressives had seen restricting court power as the main goal. And he notes in Rosenberg's piece that the court is generally elite people who are appointed to it. It's usually indirect, and it is not necessarily going to be a very majoritarian, you know, process that goes against it. I mean, the court doesn't have the power of either the sword or the purse. So it ultimately depends on the acquiescence of the general political branches and of other elite circles. And Rosenberg notes even the decisions, as we'll talk about more in coming weeks, like Miranda and other cases that seem to enhance defendants' rights, courts, police found ways to get around it. He notes, quote, police are usually able to persuade those in custody that their rights have little value and get them to actually make confessions. I think that he cited a number of studies on this, such that, there was very little evidence it was making a giant difference. And as far as the Gideon right to counsel, that's been undercut in so many different ways. Again, we'll discuss more about that coming weeks, but Stuntz, who you read, also notes that there have been a lot of systematic pressures beyond even the elitism of the courts themselves, because whatever the courts do, prosecutors and legislatures can react to those decisions and undercut them. One thing he notes that when you have a prosecutor, they have one pretty strong self interest, which is getting reelected. And one reality, and in some ways an ironic reality, is that as prosecutors looked around with greater rights for defendants, but rights that could only be exercised if the defendant had money and the means to litigate, it was actually cheaper to go after poor people. And he notes a systematic shift in local prosecutors increasing their focus on the poorest defendants, whether it was prosecuting, but also, as we'll talk about more in coming weeks, doing plea bargains to rack up large numbers of, quote, wins against criminals. While if you went after anybody, a white collar crime, or even a defendant who had means in a more traditional crime, it was a lot harder to win, partly because the Warren Court had given them more rights. Now, this issue, he notes, you have this perversity that courts did not take action to restrict those rights. They didn't make sure that defendants had court-appointed like defendants, except to the extent that they had the right. But if the legislature didn't allocate the money to have defense, the courts didn't take action. So they were, in some ways, not activist enough. And the legislatures, in many cases, deliberately undercut many of the Warren Court decisions. For example, funding for prosecution tripled between 1971 and 1990. But court-appointed counsel, there was very little increase, and the spending per case declined massively. The number of cases expanded with very little increase in the number of public defenders. Many public defenders were representing as many as 400 defendants in an 8-month period. That's something like 4 people a day, which is not a lot of lawyering on their behalf. So the state was buying over-enforcement on the prosecution side and under-defense on the defense side. And since prosecutors were driving so many indictments, there was very little chance that you weren't going to have the result that we saw, which is a massive expansion of mass incarceration. Crimes were, to some extent, increasing in the US, but also in Europe, yet you didn't end up with the same degree of mass incarceration there. So there was something else going on in the US system. And part of it is prosecutors could choose what to prosecute. And with the number of prosecutors expanding, they picked out these winner cases. And one thing the legislature did in this period was increase the penalties. If the courts were going to let people off, quote unquote, on technicalities, they were going to make not just drug dealing a crime, but mere possession a crime that could send you away for years, making sure that if the police arrested somebody, they could send them away to jail if they wanted to. And here's one of the things. The evidence of this change was that while appointed counsel was increasing by the early 70s, 80% of people going before the court had appointed counsel. But that's in some ways bad news, because it meant 80% were poor enough to qualify, which meant a generation before, half of them were far richer. But now almost nobody who had any, even middle class wealth, was generally being prosecuted. White-collar prosecutions generally moved to the federal level, both because they had the resources to prosecute it, but also because local prosecutors just didn't see it worth doing. They didn't have the resources. It was so much easier to do cases, especially with drug cases coming in, where they could do civil forfeiture, take away defendants' assets, make sure that even if they had some resources, a drug case meant they could take away the money to do a defense, while a general white-collar case, couldn't do that. Now, this is the problem, and he notes there's a vicious circle. Even as legislatures and prosecutors are maneuvering to undermine the courts, and the courts are increasing defendants' rights, you end up with this vicious circle where there's no way to cut a deal, because you have one set of constitutional rights completely controlled by the courts, while sentencing and the decision on who to prosecute is with the legislature and prosecutors, and you don't have a way to create a grand compromise, which you could in a legislative format. So the very fact of constitutionalizing these rights means that there was no simple way to compromise, trade off some defendants' rights, say, for more money spent on defense counsel. There just was no forum to do that. And so you ended up with a process which, in the wake of what was supposed to be the most liberal pro-defense decisions by the Warren Court, the rise of the largest degree of mass incarceration globally, which by the 1990s, you had 2 million people in jail or prison around the country, orders of magnitude compared to, even a generation earlier. And increasingly non-white, more focused on people of color against a Warren Court that said they were standing up for civil rights. So this is the frustrations of it. You had legislative incentives to increase, penalties because they wanted to take on the courts, and you didn't have a way to change it. Now, Michelle Alexander has not incompatible, but partly a different take, which is to understand policing, criminalization as part of the ongoing debate on civil rights in the 1960s. If the civil rights protests and mass action helped drive the 1964 and 1965 Civil Rights Acts, which defended African Americans and other minorities against discrimination and restored voting rights, those who had fought those laws immediately pivoted to the war on crime as the way to systematically continue the disenfranchisement of the same people, since people who go to prison generally lose their right to vote. They lose a whole set of protections. You're not going to discriminate against somebody because they're black, but you're going to discriminate because they have a arrest record. And discrimination based on arrest records are massive in our society. So she notes that you can see the exact same folks who were fighting civil rights would then lead the fights over crime bills for coming years. And it wasn't something that changed massively. We would see the main thing that changed was a number of the folks who had been Democrats in the Democratic Party fighting these issues migrated to the Republican Party in this period, what was then called, the Southern strategy within the Republican Party. And this was partly driven through what was called, backlash politics. Mentions Thomas and Mary Etzel in their book Chain Reaction, which was driving a politics of racial resentment amongst white working class voters to drive them from the Democratic Party over to the Republican Party. And you would see this with like polls saying, oh, communists, Negroes were driving riots. And this was part of the politics that would go from the Great Society in 1964 to Richard Nixon winning in 1968. And the war on crime would become a staple of politics for the next generation. Up until today, you still have heard of this in recent elections. So it's worth understanding, and we're going to talk about this throughout the court, that you can't talk about constitutional law in the abstract. If the first class we talked about Reconstruction and the constitutional law of that period, the whole last 50 to 60 years, constitutional law has been in a particular political period. It has reflected changes in those politics as crime increased, but also as the backlash against crime shifted the politics of the country and of the parties. And so as we talk about constitutional rights and criminal procedure, it's always worth understanding and thinking about what year are we when this decision comes down? How is it fitting into the politics of that year and that period? So with that said, enjoy the discussion for the next day or two, and I look forward to everybody's reaction posts and discussion and the essays you're going to submit on Thursday. Talk to you soon.